Folder two. It will have restore folder. Please speak loudly. Is your speaker on? Yes. Yes, please speak loudly. Yes. 18. Okay. All sides are represented. Matter stands adjourned on the prayer made by learned counsel for the petitioner. List after a week.
Lordship, item 22. Lordship, I want to take adjournment for today, Lordship. Lordship, on earlier occasion, asked question regarding admissibility of the family identity card, Lordship. Can it be on 7th of November, Lordship?
7th of November. You have informed Mr. Chaudhary?
I have not informed, Lordship.
Okay. Okay, we'll consider it. I'm making a note. Yes.
Ship item number 70, the petitioner, the consent of the other party for adjournment.
17, you want an adjournment? Okay, but this is a criminal writ petition. Can't be adjourned like that. Let us see the records. Item 17. No, please wait. Here will require the additional Solicitor General of India.
Ship senior is out of
No, that's okay. We'll take note of that. Just be here. Just don't let it be. And just don't let there be a default. Be here. We'll take care of it.
Upgraded item 27.
Yes, 27.
Notice দিছিল sir.
Okay. Then usual turn.
Daily list item 1.
Yeah, please, my lord. My lord, in this case, my lord, as per order of the honorable court, my lord, dated 15/3/2023. Today itself, I have filed an additional affidavit, my lord. So let it come next week, any date, my lord. Let it come next week, any date, my lord. As per order of the order dated 15/3/2023, my lord.
15.
Yes, my lord.
You file it.
Yes, today itself, I have filed.
Okay, you have filed.
Yes.
Filed by the petitioner.
Obliging.
Item 2.
May it please your lordship. My lord, my grievance is, my lord, issuance of a detention order, my lord, on dated 14/5/2024.
NDPS.
My lordship.
Okay.
You have to file your objections.
My lordship. (14/5/2024), page 30, my lord.
See, question number 1, 2, 3, and 4, my lord. Six. NCB, my lord, SC Kyle is there, my lord.
Sponsoring authority, my lord. Respondent 5. NCB, my lord.
NCB, my lord. Fine.
My lordship. This is the sponsoring authority, my lord.
SC Kyle is there, my lord. So I'll inform, my lord. My lord.
We have to pay for a date, my lord, because
He is detained where? In Assam?
my lordship.
Detention, yes.
Detention in Assam, my lord.
Assam.
Guwahati Central Jail, my lord.
By the,
Illegal detention case, my lord. That is why, my lord.
by the central government.
Issued by the central government.
Central
Issued
government.
by the central government. Not by the state.
You file your objections,
My lord.
if any.
1311.
My lordship. I'm highly obliged.
Problem.
Item 3.
Yeah, please. Page 28, may be so. Page 28. Yes, Lord. Third paragraph, Lordship. The submitted, Lordship, the submitted voter list are verified by OP from the election office, Dhuburi, but all the voter list are electronic certified copy of electoral roll, and hence contents of the documents is not proved by the authority, and hence this exhibits cannot telling with the primary evidence. Accordingly, Lordship, my case is not considered. And my voter list, Lordship, may be seen Case 32, where my father name was enrolled. Case 32.
Heard Mr. A.T. Sarkar, the counsel for the petitioner. Mr. G. Sharma, learned standing counsel for the Home Department, representing respondent number 2
And 6, Lordship.
and 6, Mr. M. Kuli, learned
H. Cooley.
H. Kuli, learned counsel, appearing on behalf of Mr. A.I. Adi, standing counsel for respondent number 3, Mr. P. Sharma, learned government advocate, appearing for respondent number 5. And Ms. S. Barwa, learned CGC, representing respondent number 1, are present. Next para. The learned standing counsel for the Home Department shall obtain instructions as to whether they would be appearing for respondent number 4. Next para. The legality of the opinion dated 8/1/2024 passed by the learned member, Foreigners Tribunal number 1, Dhubri, in FT case number 2480/D/11, arising out of reference reference, being IMDT case number 813 of 2003, is held in this petition filed under Article 226 of the Constitution of India. Next one. Before admission, the court would like to peruse the records of the learned tribunal. Footstop. Accordingly, the registry shall call for the aforesaid record from the concerned tribunal. Next para. In the meanwhile, the learned counsel for the petitioner shall serve requisite extra copies of the writ petition to the learned CGC, government advocate, as well as departmental counsel in course of the within 2 days, 2 working days. Next one. In the meanwhile, the petitioner shall appear before the Superintendent of Police, will give bail 5,000 rupees to the satisfaction of Superintendent of Police, border, within bracket border, Dhubri. Next one, list after 4 weeks on receipt of the records from the learned tribunal.
Deeply affected.
Item 4,
You'll have to take bail within 10 days. Within 10 days. Bail within 10 days, huh? Appear within 10 days. Yes, Mr. Biswas.
May I please, Your Lordship, before starting my submission, may I draw your attention kindly, para 17 of the opinion, para 17, page 66, madam,
66.
66. Para 17, 17.
6.
We
Yes.
don't have it here.
Yes,
Yes.
We don't have.
Yes, Lordship.
The last page
47.
we are holding
47?
is page 47.
Is it WPC 5231?
Madam, may I take your Lordship, para 17 of the opinion?
Yes.
ठीक है तो कहता 47. How?
Yes.
It is wrongly written at 66 minutes, 47 actually. Melody, I am reading from a conjoint reading of the exhibit 1 with DW 1, 2, 3. It has again been ascertained that OP's father had resided in Assam at different points of time with no real intention to permanently reside in the state. From the date of his with no real intention to permanently reside in the state from the date of his first entry into it sometime in 1166. And therefore, he did not register himself as the voter of Assam until 1997, joined by his wife, Fazila Khatun, and two others, and therefore neither of the OP father nor her mother was eligible to acquire deemed status of Indian citizenship in terms of 6A of the Citizenship Act. Thereafter, in view of the above, summoning up the 1, 2, 3, 4, 5, 6 and stands rejected as not proved in terms of the 6A of this Citizenship Act. Then my opinion I am coming. Sir, in my opinion, OP could not discharge the burden of the proving that her father Kabiluddin and the mother Fazila Khatun had ordinarily resided in Assam as envisaged under Section 6A2 of Citizenship Act, and they were in conjugal relationship in the Assam at the time of OP's probable birth in around 1974, or that she herself has been residing in Assam since 1166, and therefore she was a citizen of India either under Section 3 or 6A2 of the Citizenship Act. This I could not understand, madam.
But then you'll have to approach someone who can give you, who can give you advice.
And moreover, my lord,
We have rendered ourselves incompetent to give you advice.
no, yes, but no, why not, madam?
No,
But I was thinking, that means I am a citizenship under Section 6A2 of Citizenship Act.
no,
Therefore, she was a citizen of India either under Section 3 or 6A of the Citizenship Act.
no. This is, you see, it's very simple.
Yeah.
He said that you have did not discharge your burden.
Yeah.
Then it says or that. So or that would mean only
Well,
negative.
in the para 17, it is seen that the learned member has verified the documents of 1966. But they think that without any intention to remain in Assam permanently.
No, it says that besides whatever has been said in the beginning of the paragraph, the tribunal has also rejected the presumption that you were residing in Assam before 1/1/1966 and consequently you are a citizen of India. That has been rejected.
But the fact remains that there was the requirements of 66 of my father.
That you are
Old song of Bhupen Hazarika, Ami Ati Jajar Bor. So without
You're
intention
right,
to reside anywhere.
And moreover, my lord, one thing, to my information from my client, that there was no witness of DW 2 and 3. The learned member has mentioned that from the conjoint reading of the exhibit 1 with DW 1, 2, 3. That's why I pray that my lord kindly call for the recordsman to verify whether 2, 3 were there. That's why we have not taken any stand on the 2, 3. We could not produce it before your lordship also. We have applied for certified copy also.
page number 41, it refers.
Yes, 2, 3 you have not examined. And DW1 is the herself examined before the tribunal.
No. I think you are wrongly interpreting it. Mr.
Yes, sir.
Biswas, please come to page 41. My esteemed brother has told you. Exhibit 1, for page 41, there is a column. Exhibit 1. You got it?
Exhibit one, but
Correct.
it
After
is an-
exhibit
it is
1,
an extract
after,
certificate
no,
copy of Chita.
forget that. After exhibit 1 is miscellaneous documents. And these miscellaneous documents are marked as D1, D2, D3. These are not DW1.
Oh.
Yes.
It's very simple.
3 miscellaneous documents.
There are 3 miscellaneous documents, and therefore court applies its mind and says that these documents do not lead to a conclusion that you are a citizen of India or that you have entered into India with a view to reside permanently.
You have not applied for these documents. Your,
I have not applied.
your client must be having these documents.
And you see, this doesn't help you because of the fact that D1, we have seen this, that's why we are saying that this D1 is a cattle purchase slip dated 39 as 1973. D2 is show cause notice by certificate officer of 15/11/1983. And another show cause notice is 14/6/1984. So it does not help you to establish your entry into India prior to the appointed date.
Yes, sir. That's true. That's true, madam. Then now, madam, I am submitting.
And then you see you have shown exhibit 1. Please come to that page 41, exhibit 1.
Yes.
Exhibit 1 is a document which is settled with Rahul Amin and mutated in the name of Ajimuddin Kabeluddin by virtue of purchase in 1962.
Yes, madam. That I have brought with the
Correct.
lordship, madam.
Now, what is the name of your father?
Kabiluddin, my father's name.
But what is another document to show that you are the,
Kabiluddin is my father, madam.
no, how do you show, how have you shown that?
My lord, page 14, your lordship will find the English translation, and Jawabandi is there, madam.
No, I understand. You see, I could lay my hands to the property of one of the uh, past presidents of the United States of America who has a property in West Bengal.
Yes. Madam.
Have you seen that property?
No, I have not seen.
No. That is Trump Towers in Salt Lake. Now, I can lay my hands on that. Or forget me, if A procures a document of Trump Towers, will it make him a son of the ex-president of United States? Document is there, but you have to connect it with the
But Kabiluddin, I have connected with my Kabinnama.
where is that?
It is, I have my next madam.
It shows that
Page 24, kindly, madam.
24.
Yes.
Get to court.
I can come.
Basically, there is no connection. There is no reason.
Would work with 74 born. 4 born.
আজিতো অহা নাই।
Document.
কপি করে না
He appeared to have a very, very difficult case because the fact that under the Assam Muslim marriage and divorce registration rules prior to its repeal, did not have a provision to give a certified copy. It merely gives you a copy of the extract for which you don't have to pay any court fee stamps. And then it says then that is under section rule 50 and under 51, if it is required to be produced before a court, it shall be only by the Muslim registrar or other district registrar deputed for that purpose. So that's why the tribunal has rejected this Kabinnama, having not been proved in accordance with the
Provision of law.
Okay. Heard Mr. S.C. Biswas, Learned Counsel for the petitioner. Mr. G. Sharma, and its standing counsel for respondent number. Standing counsel for the Home Department representing respondent number 2 and 6. Ms. S. Barwal and CEC appearing for respondent number 1. Mr. H. Lee, Learned Standing Counsel for Learned Counsel appearing on behalf of Mr. A.I. Ali, Standing Counsel for respondent number 3. and Mr. P. Sharma, and government advocate appearing for respondent number 5. Next, the learned standing counsel for the Home Department shall obtain instructions as to whether they would be representing respondent number 4. Next paragraph. The opinion dated (18/4/2024) passed by the Learned Foreigners Tribunal number 11th Barpeta at Servo in within bracket BPT oblique 11th bracket close FT 1989 oblique 2017 is assailed by filing this writ petition under Article 226 of the Constitution of India. Before admission, the court is inclined to peruse the records of the learned tribunal. Stop accordingly, comma, the registry shall requisition the records of the FT case referred above from the concerned tribunal. Next para. In the meanwhile, the learned counsel for the petitioner shall provide requisite extra copies of the writ petition to the learned CGC, state as well as learned departmental counsel within 2 working days. Next para. In the interim, the bail of rupees 5,000 with all those conditions to the satisfaction of Superintendent of Police within bracket border Borpeta. Before that, you also write that it will appear before the SP border within 10 days from today. And furnish bail bond like that. Huh? Next, list after 4 weeks on receipt of the records of the learned tribunal.
Item 5.
My lord, the opinion in at page 13, my lord. But prior to that, my lord,
Page
page 13, my lord, the opinion. But prior to that, my lord, I'd like to take to page 55, my lord. The 1970 brutalist of my father, man. Page 55.
just a moment.
মানে আজি অকল এটাই আপগ্ৰেড হৈছে যাৰ লগত আহি থাকে যাৰ সেইবিলাক যদি অৰ্ডাৰ চাইছেন হয় মাতিছো হোৱা নাই এতিয়া এই লাষ্টত
My lord, I have annexed my lord, the voter list of my father of 1970, my lord. That is at page, my lord, 55. Can you see, my lord?
এই থাকে সেইবিলাক ৰাতিপুৱা প্ৰথম নটা হয় চব অৰ্ডাৰ চাইলে এটাই আছে আৰু আপোনালোকে একো নহয় তাৰকে কাষ্টম এনেও লাষ্টতে অৰ্ডাৰ চাইছিলোঁ
Exhibit 5, that document is at page, my lord, at page 60. Translated copy is at page 59, my lord. The link, my lord, I have established. Page 59, my lord. It's the translated copy, my lord. Translated in English. Next page, my lord, in vernacular, 60.
You read the evidence, I believe, DW3.
My lord.
Yes, examination by the tribunal. Can we help you?
No, it is, my notice should go, my lord. Thanks, my lord.
What was exhibit 1?
Exhibit 1 is, my lord,
Discussed in the opinion.
2.
Exhibit 1.
Exhibit 1 is not mentioned, my lord. But my lord, exhibit 3 and exhibit 5 is my lord link document, my lord.
So what was exhibit 1?
Exhibit 1, my lord, it's mentioned here, my lord.
Was there any exhibit 1?
Exhibit 1 is not mentioned here, my lord.
When take what is it? 1 is not discussed. Then there is no 6. I don't know why it is numbered like that. There is no 1. And there is no 6. Rest everything is discussed. Maybe we don't.
Probably, my lord, and exhibit 1, which is written exhibit 4, my lord.
Huh?
KA 4, my lord.
Where? Page
At
number?
page 23, my lord. Page 23, third para, para number 30.
46.
Oh, 79. Aku kudu begini.
Although the records. So we call for the records at this stage.
Yes, that must.
You are already in the ICU. We don't know whether you'll survive that long. Heard, Mr.
At least only give me a chance, my lord, so that I can argue here.
That's what we said. You're already put in the ICU. Whether you survive that long, we don't know. Let us see what the records will be. Heard, Mr. S. Rahman, the counsel for the petitioner, Mr. Who's for the union? P.S. Lokor. Oh, MS.
Himantini Borwa.
S.
As
Borwa. APS for the Union of India. Then Mr. G. Mr. J. Pine for respondent number 2,
2, 3,
3, 5, 2, 3, and 5. Mr. P. Sharma for respondent number 4, and Mr. Puli for respondent number 6. The writ petition is directed against the opinion dated 4/1/2021, by which the member foreigners tribunal number 7, Borpeta, by opinion dated 4/1/2021, passed in FT 05/2018, answered the reference made before the tribunal, in affirmative and in favor of the state. Stop. The tribunal opined that the petitioner is a foreigner/illegal migrant who had entered Assam on or after 25/03/1971. Stop. Before proceeding further in the matter, this court would like to examine the tribunal records. Stop. The registry is directed to procure the tribunal records connected to FT case number so-and-so from Foreigners Tribunal number 7, Borpeta. Stop. Matter be listed after 3 weeks upon receipt of the records. Stop. Meanwhile, petitioner will appear before the SP border Borpeta
Borpeta, my lord.
within a period of 10 days from today. And if the petitioner furnishes a bail bond of rupees 5,000, the petitioner will be permitted to remain on bail and shall not be deported out of the country without leave of the court. Stop. The SP border Borpeta will also record the biometrics of the iris of both the eyes and the fingerprints of the petitioner, and record other particulars, including contact number and photographs, for ensuring presence of the petitioner as and when required. So, matter be listed accordingly upon receipt of the case records.
Right.
Item 6.
Yeah, please, Lordship. My lord, the petitioner exhibited, my lord, 10 numbers of documents, my lord, including the voter list of
Yes.
my lord, voter list of 1965. His grandparents' name has been recorded, my lord, and the petitioner name has been recorded with his parents, my lord. Voter list of 2010, my lord. And mother of the petitioner deposed as DW2, my lord.
Wherever you see there's something more difficult to be so difficult. Three. We are issuing notice here. But Mr. S.A. Ahmed, Learned Counsel for the petitioner, Mr. G. Paying, sorry, MS Exporter for Learned CGC for respondent 1, Mr. G. Paying for respondent number
3 and 6, madam.
3 and 6. Mr. Cooley for respondent number 2. Oh, you're there. You're Mr. M. Kalita for respondent number 2. Mr. P. Sharma for respondent number 3.
5.
Sorry, 5. 5. What about respondent 4? Who appears for respondent 4?
My lord, we have written, my lord, probably it will be given to us, my lord. Let us wait for other 1 week.
All right. This writ petition is directed against the impugned order dated 29/12, sorry.
2020, my lord.
2007-2023, passed by Member Foreigners Tribunal, Borpeta 11, in case number BPT/11 FT 1605 of 2017, page number 72. Whereby the reference made by the state against the petitioner was answered in affirmative, and the petitioner was and the tribunal opined that the petitioner failed to discharge the pardon and was accordingly declared as an illegal migrant. Stop. Para, having heard learned counsel for the parties, let notice issue returnable 4 weeks. Since the respondents are represented by the respective councils, notices are waived, our extra copies be furnished within a period of 1 week from today. However, steps on respondent 4 be taken within 1 week from today by usual course and registered post. Meanwhile, the petitioner, if not already detained by the respondent authorities, shall appear before the SP border Borpeta within 10 days from today. And if the petitioner furnishes a bail bond of rupees 5,000, petitioner shall be permitted to remain on bail and shall not be deported out of the country without leave of the court. When the petitioner appears before the SP border, her biometrics, fingerprints, photograph, information, and telephone numbers shall be recorded by the SP board. Yes, recording.
Obliged.
Item 7.
Lordship, time being, Lordship. For the time being, Lordship.
Time being.
Item 8.
Maple Lordship. Impugn order is page 65. In this case, my lord, petitioner's father reduced evidence as DW2, my lord. Exhibit is page 63, Barnacular. Land document. Land document.
Page 50. But then again, you are
Indicate document Mona and motivator says. Means can you manufacture for it? Oh, okay.
Mr. Payam, we are issuing notice in this matter.
Yes. Only, my lord, I'd like to point out the Jamabandi copy, when the case was initiated, at that time, my lord, his name, her name was not mutated at that time. Her name was subsequently mutated, even after filing of the WS. Only after filing of the WS and evidence of the my lord PW1. This has been created.
After DW1,
Yes. This is brought by DW2, the project. my lord.
is bought by DW2.
Yes, ma'am.
Can you come to page 50?
Yes. Yes.
So apparent a thing did not come to the notice of your friend. Heard. Mr. A.M. Ahmed, legal counsel for the petitioner. Respondents. No. Ms. S. Barwan and CGC appearing for respondent number 1. Mr. J. Payak, Leonard, standing counsel for the Home Department, appearing for respondent number 2 and 4. Mr. P. Sharma, and government advocate appearing for respondent number 3. And Mr. M. Karita, learned counsel appearing on behalf of Ms. P. Barwa, standing counsel for respondent number 5. Next para, the learned standing counsel for the Home Department shall take instructions as to whether they would be appearing for respondent number 6. Until then, issuance of notice on no, not that so on 6. Full stop. Next para. The opinion dated 20 June 2023, passed by the London member, Foreigners Tribunal 5th Borpeta, in case number FT within bracket 5th bracket close 5140/2017, arising out of reference FT case number 333/2016, thereby declaring the petitioner to be a foreigner of post 1971 stream, is assailed by filing this writ petition under Article 226 of the Constitution of India. Issue notice returnable in 4 weeks. So requisite extra copies of the writ petition be served on the learned state and learned CGC, state and department council within 3 working days. Next para. The petitioner shall take steps for service of notice and respond by 6 by registered post with AD. And in the meanwhile, the learned standing counsel for the Home Department shall also obtain instructions as to whether they would be representing respondent number 6. Next person, let the records of the aforesaid case be requisitioned from the concerned tribunal by the registry. Next person. In the event the petitioner has not yet been deported, she would appear before the Superintendent of Police within bracket border, Borpeta, within 10 days. And on furnishing bill bond, 5,000 SP border, Borpeta. With all those conditions. Next list. After 4 weeks on receipt of the records from the tribunal, learned tribunal.
Complex. Pending item 7.
May I please? My lord, in this case, my lord, the petitioner was declared as foreigner, my lord, by imperial order that 11/19, page 28 onwards, my lord. Like this was ex parte order. He never received any notice, my lord. It is also reflected in the order, my lord. In paragraph 2, my lord, is specifically mentioned, my lord. Page 30, my lord.
Page
30, my lord.
30.
Yes, my lord. Huh?
This is due compliance of
35F.
35F.
At least is this record maybe called Melody. Otherwise, the para 2 says Melody. Sir.
How did you come to know about this order?
My lord, in the month of August, my lord, we have come to know when police visited our residence. We have mentioned, my lord. We have mentioned that when police visited our residence, we came to know, my lord. In para 7, my lord. Only in the month of August came, immediately we applied for a certified copy. And on getting the certified copy, we approached the honorable court. Para 7, page 6, my lord.
You see, you have written something extra. It is compelling us to peruse the other documents. And you have demolished your own case with that extra words used in the petition. You see, come to paragraph 6 at page 5 of your writ petition. The petitioner hails from Kachumara Nonke village, and for some time he also resided in Pampara village during the year in the 1997. Correct?
Yes, my lord. Whatever is-
And then you left the village in the year 1998. Come to page 29. The reference is of P933 of 98. So therefore, after the reference, you vanished. You don't give better particulars. When you left, those things are not there.
Reference actually, maybe 98, my lord, exact date when he left, that is not.
No, no, if you say 98, that means January 1 to December 31st.
Exact date is not.
No, we don't know. You said true to my knowledge. Affidavits of yours. Come to page 10, paragraph 2, 3. Statement made in paragraph 6 is true to your knowledge.
Exact date actually is not known, my lord.
One extra word.
The only manner when the opportunity be given, my lord, will, because he has got all the documents, my lord, to prove that he is an Indian citizen. So if an opportunity is given, we will prove our case, my lord, before a tribunal, my lord.
Call for the report. It was called for the report. Yeah. Yes.
Mr. Pang,
My lord.
once that is admitted that the notice was duly served,
Yes, my lord, that is as per law.
now if you don't seriously object, You can impose some cost and then send back the matter, let him reduce evidence.
That can be done, my lord. Because admittedly, my lord, the notice was served properly
Property,
as
sir.
far as
Property, sir.
there is no
No.
illegality in the order. So only for the interest of justice, if your lordship allowed, then impose some cost on that. In case of my lord expertise, there is review provision for them. But yes, but that is within 3 months,
30 days,
30 days.
30 days or 3 months.
3 months. 30 days.
We are referring to 3C.
Yes, ma'am.
Yes, please.
Yes, ma'am.
When did it come to your knowledge?
In the August month, in the month of August, my lord.
Where have you stated?
In paragraph 7, my lord.
Please.
Heard Mr. I. Chaudhary, learned counsel for the petitioner. Respondents are safe. Next problem. The ex parte opinion dated 11/11/2019 passed by the learned member from a Foreigners Tribunal number 7th of Borbetta in case number FT 976 of 2017. Arising out of reference case number 3993 of 98 is assailed in this writ petition filed under Article 226 of the Constitution of India. Before admission, the court is inclined to peruse the records of the aforesaid case, full stop, accordingly, comma. The registry shall requisition the records of the FT case referred above from the concerned tribunal. Next paragraph. Requisite extra copies of the writ petition be served on the learned CGC, State and Learned Departmental Council within 3 working days. Next paragraph. As an interim in the event the petitioner is not taken into custody and deported, the petitioner shall appear before the Superintendent of Police within bracket border, Borbetta, within 10 days from today, and furnishing a bail bond of rupees 5,000 with the satisfaction of the Superintendent of Police within bracket border, Borbetta. Bail with all those conditions. Next paragraph. List after 4 weeks on receipt of the records from the learned tribunal. Give a date, give a fixed date. How much time? 3 weeks will come. Records will come. How much time?
At least 15 days time. Madam.
After 3 weeks, make it.
Registry will bring. Registry is directed to bring the records.
Yes. We'll take a short break and come back.
Yes, sir.
5910, Lordship. So I pray, Lordship, if after addition is possible, Lordship, kindly take up the matter. With due permission from the other Lordship.
26.
Item 9.
Yes.
May please, Lord. Not the impugn opinion, my lord, page 73, my lord. And the petitioner, my lord, executed the voter list of 1966, 70, 85, and 1990, and 2010. And land document was also produced, my lord, sale deed as well as, my lord, mutation in the name of petitioner and her brothers. And in the inquiry report, lordship, page 43, the first LBO, my lord, made inquiry. The voter list of the father was produced. And it was recorded, my lord. Thereafter, nothing has been mentioned. No column has been filled up. Everything is vacant, my lord. Stream was not, my lord, identified. And impugn findings, my lord, that after, my lord, 1985, there's a gap, my lord, from 70, after 70, my lord, their name, they have produced, my lord, voter list of 85. In paragraph, page 76. In the summary, my lord. Summary number 6, my lord. The member, my lord, admitted that my father is, my lord, entered prior to 1166. Mother's name appeared in prior to, my lord, 70. After 70, we produced voter list of 85. These gap, my lord, he has taken into consideration.
Ms. S. Barwa for respondent number 1, CGC for respondent number 1. Mr. G. Sharma, the net standing counsel for the Home Department, preparing for respondent number 2 and 6. Mr. H. Puli, learned counsel appearing on behalf of Ms. P. Barwa, standing counsel for respondent number 3.
H.
Mr. A. Ali. For AI Ali. For AI Ali. Standing counsel for respondent number 3. Mr. R.K. Talukdar, learned government advocate appearing for respondent number 5. Next. Opinion dated 3/3/2023. Passed in FT case number 1390 of 2017. Arising out of reference IM within bracket D, bracket was T case number 7455 within bracket capital A. By the learned member from Foreigners Tribunal, 11th, Borpeta, or thereby declaring the petitioner to be not a citizen of India is assailed in this writ petition filed under Article 226 of the Constitution of India. Issue notice returnable in 4 weeks. Requisite extra copies of the writ petition be served on the learned CGC, State and Learned Department Council within 3 working days. Next paragraph. The learned standing counsel for the Home Department shall take instructions as to whether they would be appearing for respondent number 4. However, in the meantime, the petitioner shall take steps for service of notice on respondent number 4 by registered post with AD within 3 days. Next paragraph. In the event the petitioner has not been detained and deported, or the petitioner shall appear before the Superintendent of Police within bracket border, Borpeta, within 10 days and furnish a bill bond of rupees 5,000 with the satisfaction of the said authority. Give those conditions of Iris bill. Next paragraph. Let the records after notice, give that records, call for the records. Next one, list after 4 weeks. Awaiting receipt of records of the learned tribunal. Okay.
Upgraded item 26.
Make please, your lordship. My lord. Impugn order is page 97, lordship. Whatever lordship, in this case, the petitioner lordship prayed for filing additional written statement lordship in FPK is lordship, because some of the documents was not available while filing the written statement lordship. But that petition was rejected. Operative portion of the impugn order, page 98, lordship. 97. First 2 paragraphs, lordship.
Something is wrong here.
Lordship, please.
In the copy which I am having,
Lordship.
You see, come to the index page.
Lordship.
Serial number 8 is annexure 8. Copy of written statement in your index.
Lordship, please.
Correct.
Lordship.
Come to page 49, that is deposition. Now, where is your written statement?
Written statement, lordship, I have an next lordship.
Which page?
I'm just coming, lordship. Written statement page, deposition of It is page 7. Lordship, page 66, Lordship. Sorry, Lordship, page 66, Lordship.
66.
Lordship. Page 66 to Lordship, page 86, Lordship. Then Lordship, cross, Lordship. Page 88, Lordship. Cross has not yet been. Further cross is reserved, Lordship. Page 89 is the original copy, Lordship. Last line, Lordship. Annexure 10. Further cross reserved, Lordship.
No, but you see, the problem is that in page 90,
Lordship.
you don't say what documents. It's just vague. Even we will reject that application.
Lordship, actually, sometimes Lordship, the learned code below. But I clearly submit, Lordship, only regarding his school documents and Jawanbandi, Lordship.
No, but how will you infer what you want to bring on record? Because you have made such a vague
Lordship,
petition.
actually, Lordship, during the Lordship, the filing the written statement as well as evidence, Lordship, they could not collect it from the school, Lordship, where he studied, Lordship. In a cracks, Lordship, with all respect, I am submitting Lordship petitioner school records admission register of 1967 to 71, Lordship, which he studied.
No, but still here also it is vague. Come to page 30, paragraph 13. You don't specify the documents, so it becomes very difficult.
Lordship, if necessary, Lordship, paragraph
13.
of my petition, Lordship.
Because what is the document we can't understand.
Oh, that is
What is the document you are wanting? We don't understand from your petition.
Lordship. So, all respect, Lordship, if necessary, Lordship, I will file that specific documents which I want to file, Lordship, because only he has submitted nearly all the documents of his forefather as well as his voter list, everything, Lordship, from since 1900, all documents. He is a
Where is your document? Exhibit A.
Exhibit A, Lordship, is the school. Oh, sorry, Exhibit A. I have copy of all this, Lordship. I make it what exhibits, Lordship, submitted before the Honorable Court, Lordship. I can, Lordship, because it will make bulky, because of which I did not.
No, don't worry, we have read bulkier matters than this.
Lordship. Exhibit A, page number 2, Lordship, is Mojonmia Majumdar, Lordship. It was 7/3/1900 deed. Page 2, Lordship, Exhibit A. It was a deed of 7/3/1900. Lordship, Exhibit B, page 4, Lordship, It was a deed of 16/7/1919. It was Abdul Wahab Majumdar, that is his grandfather, Lordship. Below, Lordship, then Lordship, next one. Sorry, Lordship.
Which is the order you are challenging?
Here, Lordship, page 80. If you know that. That is page 97, Lordship, annexure 12.
97. Where is the concerned petition?
Lordship, petition is page. Page is 1990, Lordship.
No, something is wrong.
Lordship, please.
Something is wrong. Page 90 does not match with the observation made in page 97. Page 90, the prayer is, that is why we posed you that question. Page 90, the prayer is, Your Honor would be pleased to allow the petition pass necessary order for the ends of justice. So, what prayer we don't know.
Lordship,
Now,
here is the petition, Lordship. During the filing of the deposition, unfortunately did not paragraph 3, Lordship. Submit is some crucial, important, vital, missing document, papers, etc. before this honorable court of tribunal. Now he found collected some documents, papers, Lordship, and the petitioner's OP will submit the same relevant documents and papers in support of additional evidence, Lordship.
Correct.
Page 90, Lordship. On the basis of that application, Lordship,
No, but look at page 97. Heard Mr. H.A.H. Chaudhary,
Lordship,
counsel appearing for the petitioner, proceeding has been heard at length on petition number 341,
Lordship,
filed under order 6/17, read with section 151 CPC.
Lordship,
So therefore, you are appears to be incorrectly instructed.
Lordship, that is the page that was put up on 29/8/2024, page 90, Lordship application 37 to
No,
the
we don't know that, but here in page 90,
Lordship,
order 6/17,
Lordship,
read with 151 is not there.
Lordship. That
So
was
therefore, you are either wrongly instructed or this is a wrong petition you are referring to.
Lordship,
Because here you want some documents. And
Lordship.
here, page 97 is amendment of your written statement.
Lordship, may I pray, Lordship? Because that application was a certified copy of my, along with all this, Lordship, regarding this.
Because you see, come to page 100.
Lordship. 100 is another application, Lordship. That was for,
No, 100 is not an application. This same thing, 341 was rejected. Order 6/17 is mentioned again in page 100.
Lordship.
Order
No,
6/17.
same order, it's a complete order, Lordship.
So that's
Yes.
why you see in the we are showing you first paragraph and
Lordship,
second last
Lordship,
paragraph.
Lordship, correct, Lordship.
Both
That to be,
places.
that to be uncertain, Lordship, may I pray, Lordship, let the records may be called for, because petitioner has,
No, we are not staying the proceedings. That is the difficult proposition.
because it is on fixed on 29th,
We
Lordship.
can't
for
help it
judgment,
because we are not staying the proceedings.
Lordship. So I pray, Lordship, because otherwise, Lordship, otherwise the petitioner will suffer, Lordship, irreparable loss.
We can't do it.
Lordship, this application, only on the basis of that application, the learned court has written, Lordship, this application. May I read the entire order, Lordship? Even
Yes.
she entered appearance, Lordship. Learned court has written, but he is a man, Lordship. So with all due respect, Lordship, I am submitting, Lordship. There is some infirmity in the order, either, Lordship, because the what application he has applied, he has obtained the certificate copy, Lordship, of that.
No, you see, I will not remember the judgment, but I can definitely find it out.
Ji, Lordship.
There is an authority on the point that once a matter is reserved for judgment,
Lordship.
it is not on board and therefore it cannot be stayed.
But Lordship, I am coming, Lordship, that page 89.
No, come to page 100.
Lordship, correct.
Fixing again for so and so for further hearing and argument, if any, and also for judgment.
Lordship, but the cross has not yet been completed, Lordship. Page 89. Page 89, original copy. Further cross reserved, Lordship. Page 89, annexure 10.
This is of which date?
Nothing, Lordship. There is no mention about the date, Lordship. Court is, it is a certified copy of that, Lordship. I have original copy of that.
No, but we don't know the date.
Lordship, they are not putting the date, Lordship. Lordship, my petitioner, I instructed him to, Lordship, because it said there is no date, Lordship, after submission of the evidence, Lordship.
You see, there is no date here because of a particular reason.
Lordship.
What has happened here in the evidence on affidavit,
Lordship.
in the back page, they have started the cross-examination. And therefore, the date is not there.
But
So
here,
there is-
as my advocate has informed, Lordship,
presumption that
here that cross-examination was written in the written statement, Lordship. My advocates informed, Lordship, that that cross-examination was written in the backside of the written statement, Lordship, not in the evidence part, which he has submitted. He will suffer irreparable loss, Lordship, because his cross-examination has not yet been completed, Lordship. As per page 89, Lordship, his cross-examination shows that the cross-examination has not yet been completed.
What is the implication of? What is the implication of the finding of the tribunal at page 97, last paragraph?
It has further stated that in due course of initial argument, Lordship for and on behalf of the proceeding was held on 21/3/24. After notice, Lordship, there was there had
So
the
this is prior to, prior
prior to
evidence.
cross, Lordship. I asked him, Lordship, for obtaining all the orders of the certified copies, Lordship. But the learned court is not available, Lordship, because of which, Lordship, he is not getting anything, Lordship. If the further cross, Lordship, is not completed, Lordship, then how the learned member can conclude for final judgment, Lordship, without giving any opportunity. And I have a brutal list of my father brutal list of 1965. I am a government servant, Lordship. I am a retired person, Lordship, now for a stranger, Lordship. And actually what has happened, Lordship, the first time, Lordship, the all Jawanbandis and everything, my name is also very much there in the Jawanbandi also. Father's Jawanbandi, Lordship, after father's death, my name was included, Lordship. I have original copy of that, Lordship. So that document to be, Lordship, submitted, otherwise, Lordship, petitioner will be seriously prejudiced, Lordship. It is a question of a one chance may be given, Lordship, to submit all the documents, Lordship. And this honorable court, Lordship, also page 104 and similar case of, Lordship, consider, Lordship, similar search of
No, we
circumstances,
must understand what is the nature of prayer. You see, Order 6/17
Lordship.
requires that the nature of the document, the evidence to be led, the pleadings to be amended must be spelled out. We can't give a blanket order which may permit you to bring anything on record.
With all respect, Lordship, I am submitting before this honorable court only the name of Jawanbandi, new Jawanbandi, Lordship, and school documents, Lordship, admission register, that headmaster to be called for where I studied, Lordship. In my petition, Lordship, I have shown, Lordship, the certificates were issued, Lordship, I studied in that school since 1967 to 71. That document, unless, Lordship, being on record, Lordship, the linkage will be in troubles, Lordship. So I pray, Lordship, let a single opportunity may be given to the petitioner to submit all these documents for the interest of justice, Lordship. In other matter, Lordship, this honorable court, Lordship, page 104, Lordship. 105 is the operative portion of the order, Lordship. May I kindly read, Lordship.
Where is the reference to the school certificate in your written statement?
Lordship,
Where is the reference to your being educated in a school in your written statement?
Lordship. Sometimes, Lordship, the of them, some lawyers problems also there, lordships. Good lawyers are not attending. The answer is opposite to past pages in 73 by tool number so and so, so and so.
Reading where? Reading with which
Page
page?
67, lordship.
67.
69 pages.
And the whole problem that in that time, lordship provisional certificate was submitted. Lordship original certificate was not available. Petitioner collected the original. I have the documents of original lordship, all original document. And John Mundy copy is also there. Lordship petitioner name is very much there. I Lordship is a original copy of Jawan Mundy lordship. If lordship want to tell lordship.
So these documents were referred to in your WS.
Lordship. In my WS, there is these documents are referred lordship. In my, I have marked it also. I have
68,
in my WS also lordship.
70, 67, 68.
In my WS also. It's a deposition 67 to annexure lordship, then lordship page 68. Annexure B. My deed, sale deed lordship. Father's forefather sale deed page 68 lordship. Annexure C lordship. That documents I supplied lordship. Deed of number so and so. Then lordship, my father Abdullah Majumdar died 1970 lordship. Then annexure D, Maskandar Ali son of so and so, so and so. Xerox copy of the sale register deed 1950. My father sale deed 1950 lordship. 29/11/1950. Page 69. Then annexure E lordship is the total list of my father lordship along with my other brother's lordship. I was in that time minor lordship, 1965. Then annexure F, 1970 total list.
Lordship. Lordship. His lordship order has clearly stated that, and lordship, a law has already been settled lordship regarding that. At this stage, lordship, petitioner could not introduce new documents lordship. Lordship, Nilbhan case has referred lordship 2021 1 GLT 799 lordship. Yes, lordship. From lordship, para 10 onwards, lordship. Para 10 onwards, lordship. Huh? আসলে এটা তো মেনশন আছে Lordship, para 10 onwards, Lordship.
Come to para 7 of the order, last part.
Lordship,
Thus, we
Nilbhan.
find no material on record which can satisfy the court that after the petitioner had exercised due diligence by making prayer before the learned tribunal to summon the concerned so and so, which could be recovered. So the only conclusion is that by filing petition number so and so, the petitioner has made an attempt to fill up the lacuna
Yes.
which remained after the evidence of the petitioner was closed. That is why we are asking Mr. Mazumdar as to whether the evidence is closed.
Lordship.
So that is one part. Second part is that this Nilbhan goes against Mr. Mazumdar for the reason that in para 11 we have made the discussion that the vague nature of subsequent pleading.
Yes, Lordship.
So that is why we were referring to that order 6 rule 17,
Yes, Lordship.
which it does not have at moment. So I think in this case, we can call for the records.
Yes, Lordship.
You better love.
Because in Nilbhan, we have discussed the subsequent pleadings,
Yes.
order 8 rule 9.
Yes, Lordship.
And we have also stated that it should be exercised sparingly.
Yes, Lordship.
Good. Mr. K. Mazumdar, done it, counsel for the petitioner. Mr. Chi Sharma for respondent number 3 and 6. Ms. S. Barwar and Ms. CGC for respondent number 1. For respondent number 2. Mr. M. Kalita, counsel appearing on behalf of Mr. Ms. P. Barwa, standing counsel for respondent number 2. Mr. R. K. Talukdar and the government advocate appearing for respondent number 5. By filing this petition under Article 226 of the Constitution of India, the petitioner has assailed the order dated 11/9/2024 passed by the London member, Foreigners Tribunal 6th, Silchar, by which petition number 341 of 2024 was rejected. Next paragraph. The learned counsel for the petitioner has submitted that has placed reliance on NHA 11 to the writ petition to project that the petitioner had applied, had filed a petition to call for certain relevant documents in support of additional evidence. And the same was rejected. He has further submitted by referring to where is that cross-examination page?
Lordship, page, type copy 89, Lordship, annexure 10, Lordship.
Referring to annexure 10 to the writ petition. It is submitted that as per instructions received by him, the petitioner was cross-examined. He was cross-examined by the tribunal, which is recorded at the back page of the written statement. And he specifically submits that
That was told by the Lordship.
that the petitioner has not yet been cross-examined.
Only that part, further cross-examination. only. I was certified proposed.
Next part is the next part accordingly.
May I supply the certified copy of cross-examination for verification?
Accordingly, the court is inclined to is inclined to call for the records of reference FT 6th dash D,
Yes.
capital D.
One nine-
1916 of 2023. Oh no, it will be case number FT 6th within bracket D, bracket closed, 1916 of 2023, page 97. From the Forest Tribunal 6th, Silchar. Registry shall send the requisition. Mr. Sharma, do you have scanners in your tribunal? They can send by email instead
have
of physical
to-
copies.
Lordship, I have no instruction regarding that. I can ask Lordship.
The registry shall send a requisition for the same. It diverted to the learned tribunal to send the scanned copy of the records. However, if scanning facility and mail facility is not available in the tribunal, then the original records be should be sent by the learned tribunal. Next one. Extra copies of the writ petition be served on the learned CGC, state and learned departmental council within 3 working days. Next para. List on. Give a date after 3 weeks.
2011.
2011-2024.
In the meantime, Lordship, the further proceeding may kindly.
Record to call for.
Otherwise,
Till
in the meantime, Lordship,
at the next date of listing, the further proceedings of
FT
case number
case number 1916. Lordship. Pending before.
case number FT6 within bracket D, case number 1916 of 2020, shall remain stayed. You are returning back your documents.
Lordship.
If you want to
I'll-
file it, you can file it by way of an
Lordship,
affidavit.
may I, observation may be given, Lordship.
No, no, we are not giving an observation. You may
Lordship.
do it.
Oh, Lordship, I will file additional affidavit. Much obliged, Lordship, sorry for coming. I've taken enough time, Lordship. Much.
May it please your lordships. I beg may I mention item number 8, my lord. The matter may be listed wrongly, my lord. It is shown by order, but we did not mention the matter, my lord. So the matter may kindly be adjourned for the day, my lord.
No, there is an administrative order for which these are matters are being listed. So it's not by order does not mean necessarily that by mention.
My lord, we did not mention the matter, my lord.
Nobody is telling you that you have mentioned the matter, but still it has come. There is an administrative order.
The matter may kindly be adjourned for the day, my lord. We are not prepared, my lord. As per instruction of my senior, Mr. T. Shaikia, sir,
Okay, your name?
Mr. A. Hussain, my lord.
Both sides are represented. Mr. A. Hussain, learned counsel for the petitioner, has submitted that he is not prepared with the matter. So accordingly, matter stands adjourned today. Just
In the next week, Monday,
after a week.
Tuesday, my lord.
Okay.
My lord, my lord.
Lordship, I beg to mention IA Civil 2885 2019.
No, that mention you cannot make here. This is not a regular bench.
Item number WPC 482.
This is-
Taking item number
this is-
11, Lordship.
This is not a
Six.
regular bench.
Lordship, it is item number 11. I think, Lordship, Mr. BC already informed me. He is out of station, Lordship. That is why he took consent from me, Lordship. So, Lordship, may adjourn the matter for today and fix a date as early as possible, as it's a matter of 2013. Lordship.
Okay. Okay, both sides are represented. Miss
M. Bachra on behalf of BC Chaudhary.
Ms. M. Boshal and the council appearing on behalf of Mr. B.C. Chaudhary. Council for the petitioner in WBC 4617 of 2019. Praise for adjournment. Prayer is allowed. List after a week.
11 and 11 and
11 and 12.
12 is review, Lordship. Fix a date, Lordship. Any date, Lordship.
It will come after a week
After a week.
because this is not a regular bench, so we are not fixing it.
It is tagged with this bank because review petition is there, Lordship. Lordship order reviewed,
Okay.
government file. Lordship.
It will come. Because you see, the difficulty is that I am otherwise in division bench. So
Yes.
therefore, the legislature will list it on a convenient date.
Lordship.
Hmm.
After a week, Lordship.
After a week.
Always.
Make a mention if it is not listed.
Lordship. Always.
Daily list item 1 for motion.
Yes, Mr. Gupta, what is the date of the order?
Lord, 11/12/2023, my lord.
11/12/23.
Three, my lord.
Okay. By Mr. M. Datar and counsel for the petitioner. Alleging willful disobedience of the order dated 11/12/2023 passed by this court in WPC 472 of 2022. This contempt petition has been filed under section 11 and 12 of Contempt of Courts Act, right, with Article 215 of the Constitution of India. Issue notice returnable in returnable on, give a date after 5 weeks, returnable on so and so. Petition shall take steps within 2 working days for service of notice on the respondents by registered postal AD. Next, the learned counsel for the petitioner is at liberty to collect the postal receipt number and submit postal track report prior to the next date of receipt. Next, pendency of this contempt petition shall not be a bar for the compliance of the order in reference.
412.
Apply.
Item 2.
What is the date of the order?
Lordship, date of the 12/4/2023, Lordship.
12/4/23.
23, Lordship. The relevant person kindly see, Lordship, there is a 6 months time period, Lordship. Page 14, Lordship.
Six-month time
Lordship,
for compliance.
Lordship. Page 40, Lordship.
Okay. By Mr.
DC now.
DC Nath, then possible. Same order. Page 1. Petitioners S. Okay, take steps within 2 days.
Lordship.
Issue notice.
Lordship, one prayer, Lordship, 4 and 5 is similar, Lordship. Similar, judge.
4 and 5 is similar.
Similar.
Same order.
Same.
4 and 5. Okay. Item 3.
May I please, Your Lordship?
Yes,
Order
Mr.
dated 4/10/2023, my lord. Order is 10/2023, my lord.
4/10/23.
Order is at page 10, my lord.
That's all.
Starts from
4/22.
page 11, my lord.
Okay. Same order. Petitioner. Page 1. Order. Okay, we have issued notice. Take steps within 2 days.
Oblige me.
Item 6.
Mr. Ayala.
Yeah, this case, I have challenged the appointment of the respondent number 5 as a lecturer, assistant professor in Arabic in Mangalore College. One ground.
Just a moment.
My lord.
Just a moment.
My lord.
Where is the conditions of the
Yes, well, that is at annexure 1 at page
page?
19, my lord. Lordship will get in second para last line, last but one. Age should not be more than 38 years as on 1/1/2020, my lord. In with the other condition of applications, OBC, ST and ST, my lord. So he is a general category candidate. So he on that day he is more than 40. But to get the benefit of OBC, he obtained a OBC certificate belonging to Moimul community. The address is totally different, my lord. His PRC address is completely different. He is from Mangalore, and the OBC certificate that is issued is showing the address of Horolubuk.
Okay. Yeah, issue a notice then.
No, sir.
The appointment,
He's already been appointed, but I could not obtain the appointment, my
it's
lord.
okay, the appointment will be subject to further orders of the court.
Yes, my lord.
Lordship, may I point out one thing? He is doubting the caste certificate. So
Both the committees and the my lord DC. deputy
So
commissioner.
you do it, then we'll take it up.
yes, Lordship.
Because without appropriate party, it will be improper to
Yes, ma'am.
make a mention.
So I finally implement this.
Not, not we permit you to do it. In your oral prayer, we are allowing you to do it. Mr. P. Mahantal and counsel for the petitioner has submitted at the outset that some necessary parties have been left out to be implemented as respondents. And accordingly, he prays to allow him to complete the necessary, proper and necessary parties. Next, para. Mr. A.R. Tahibulda from the Standing Officer for the Higher Education Department is present. It's for the period is over. Next, para. The petitioner, the learned counsel for the petitioner shall submit amended cost title to the AOJ's civil section, civil pending section.
Yes, civil pending section.
Plus to, who on receipt of the same shall incorporate the same in the record, and thereafter the matter be listed again in the motion column.
All right.
Item 7.
Yes.
After pardoning to my lord, the petitioners are diploma in pharmacy courses pursuing students, my lord. And they have already undergone their part 1 and part 2 examinations, my lord. And so far the part 3 examinations regarding the practical training is concerned, my lord. That was not allowed to go for by the authorities.
No, but that depends on the,
I don't know, issue short notice in these cases because.
you
it's
take
from
instructions
directly.
because.
My other will take instruction. So
Okay. But Mr. M.A.I. Hussain, learned counsel for the petitioner. Next, by the petitioners have projected that they have successfully completed the diploma in pharmacy within bracket part 1 and part Roman 2, Roman 1, Roman 2, bracket closed course. And they're waiting for practical training. This is part 3 of the said course. However, the state government has not permitted the petitioners to go for practical training. As they have studied in institutions from outside the state, which do not have affiliation to Srimanta Shankar Deva University of Health Sciences. Next, issue notice returnable in how much time?
Lordship, we give 2 weeks time after taking.
Returnable in, returnable on, give a date after 2 weeks. After 2 weeks, give a date. Returnable on so and so.
see, I am paying for 1 and 2 losses.
Petitioners, yes. Mr. K. Goel and HCC has accepted notice for respondent number 1 and 2. And Mr.
Lordship, M here.
M.
Here, Lordship. M here on behalf of
M.
B.
Here, M. Here, then the counsel appearing on behalf of Mr.
B. Gogoi, Lordship.
B. Gogoi, that is standing counsel for the health department,
Three to
representing respondent numbers 7 to
3 to 14 was.
3 to 14.
3 to 14. The name which is there in serial 16, raises an eyebrow.
Or CM Zain University Lordship.
No, others I am not aware, but this raises an eyebrow.
My lord, it's a pharmacy course, my lord. They are make party here in my lord.
No, that's okay, but the institution, name of the institution raises an eyebrow.
There are many litigations for this honorable court regarding this institution, my lord.
So, accordingly, requisite extra copies of the registration be served on them within 3 working days. Next para, the petitioners shall take steps for service of notice on the respondent numbers 15 to 20 by registered post with AD. Full stop. The learned counsel for the petitioner is at liberty to collect the postal receipt number and submit postal track report prior to the next date of listing. Next para, in addition to the postal steps, the petitioner shall serve notice on the respondent numbers 15 to 20 in the email addresses and upon service by routing the process to the registry of the court and upon service by email, an affidavit of service shall be filed by bringing on record the email addresses next para. List on
1311.
1311 before that, we write the pendency of this requisition shall not be a bar for the appropriate authority to take a decision in regard to the having regard to the grievance of the nature of grievance of the petitioners.
Item 9 is also similar, my lord. Item 9 is similar issues in item 9, my lord.
Same.
Item 9 is same, Lordship, only respondent, my brother will represent Lordship from 3 to 12. Lordship.
3 to 12.
3 to
Okay,
12,
same.
he will represent Lordship.
3 to 12, Mr. Gogoi for 1 and 2. And notices
Notice
to
Notice to my lord.
13 to Lordship.
From 13, my
16.
lord, 13 to 16, my lord.
13 to 16.
My lord.
Okay. 13 to 16. Same. Okay.
Highly obliged.
Item 10. Yes, Mr. Hussain.
May we please, your lordship. PS 16.
You see, regularization is something we can't do.
But the release of salary also there, my lord. Annexure 6, page 23, my lord. And already sanction were not released. my lord.
But there's no order of your appointment for the period 1/11/18 to 30/10/22. Is there any order? I have missed it if there is.
Whether annexer to page 16 may be produced.
Page 16.
Page 16.
Okay.
And annexer for page 20, my lord.
Page
Page 20, my lord.
20.
20. There was action shop. Subsequently is continuously working.
No. My question is, you are asking for remuneration
Yes, my lord.
for the period from 1/11/18 to 30/10/2022. If there is any appointment letter for the said period, I missed it. Is there any such appointment order for the period 1/11/18 to 30/10/22?
No extra appointment, my lord, except annexer two. No other appointment and
Issue notice,
exception is number.
take information. Heard Mr. B. Hussain, learned counsel for the petitioner, as well as Ms.
H. Tarang.
H. Tirangpi, learned standing
Pending
counsel for
counsel, Your
the
Lordship. 1, 2, and 3, Your Lordship.
standing counsel for the
All respondents.
no, just for the secondary education department representing all the respondents. Next, the petitioner claims that he was appointed as a contractual worker in the office of the Director of Secondary Education Assam from 3/10/2017 and his service was extended by order dated 18/6/2019 for the period from 1/4/2018 to 31/10/2018. It is projected that even thereafter, the petitioner continued to render service, and accordingly, by filing this writ petition under Article 226 of the Constitution of India, the petitioner is seeking a direction upon the respondent authorities to regularize his service and to pay his outstanding arrear monthly remuneration for the period from 1/11/2018 to 30/10/2022. Next paragraph. Issue notice returnable on, give a date after 5 weeks. Returnable on so and so. As the learned standing counsel for the school secondary education department has already accepted notice, requisite extra copies of the writ petition be served on her within 2 working days. Next paragraph. The pendency of this writ petition shall not be a bar for the respondent authorities to release the arrear monthly remuneration to the petitioner if he has rendered work without pay from 1/11/2018 to 30/10/2022. Next, list on Spencer.
9th of December.